have a history that was forged right here in Arusha. And that was in the courtrooms of the International Criminal Tribunal for Rwanda, ICTR. He was the prosecutor, and I was on the defense. We fought every single day. And let me tell you, fighting him daily was what they call on the job training the hard way. He is simply one of the most tenacious and brilliant legal mind, I'm telling you, I have ever encountered. And you will see it when he stands here. I am much happier, though, that we recently brokered a ceasefire thanks to a diplomatic intervention of a common friend, a professor in Australia. And on this basis, I can now call him a true brother, a true friend, and indeed a colleague. His distinguished career is a testament to that very tenacity and brilliance. His current roles include serving as chair of the Commission for International Justice and Accountability, a senior peace fellow of the Public International Law and Policy Group, and he holds prestigious fellowships in many institutions, including the United States Holocaust Memorial Museum and Oxford University. His commitment to the cause is further reflected in his service on the boards of numerous organizations, including Physicians for Human Rights, the Syrian Emergency Task Force, and the Center for International Law and Policy in Africa, among others. His path to this global stage began as a U.S. attorney in Iowa. His foundational work here in Arusha at the ICTR saw the first convictions of media leaders for incitement to genocide. He then made history as prosecutor of the Special Court for Sierra Leone, convicting former Liberian President Charles Taylor and securing the first ever convictions for sexual slavery and the use of child soldiers. From 2009 to 2015, he took this expertise to the world stage as the U.S. ambassador at large for global criminal justice, coordinating support for international tribunals, and traveling over 1.5 million miles to advance the cause of justice. He has also shaped future minds as the Father Robert Drinan, right? Drinan, visiting professor for human rights at Georgetown University. He is a true pillar of international criminal justice. What I have told you is part of his long CV, which will take me days to explain. Excellencies, ladies and gentlemen, it is my honor to welcome my former worthy adversary, Ambassador Stephen Rapp. Your Excellency, you are most welcome.
Well, thank you very much, Matthias, Dr. Matthias. It's wonderful to be with all of you here back in Arusha. I lived here with my family. My children attended school and finished school here as secondary school in Arusha when we lived here for 6 years. And coming to Arusha and coming to Tanzania, coming to East Africa is always like coming home. I was just here 2 months ago where Matthias and I met at the Arusha International Conference Center. Do we have an issue with the sound? Is it coming through? The translation. Il y a un problème avec la traduction. Il faut parler en français, peut-être. Toujours un problème? Still a problem? We have a problem with translation? I see, okay. On le temps? Okay, I can continue. As I was saying, it's wonderful to be back in Arusha, where I lived for 6 years, and it is like coming home. I'm here today to talk about international criminal law, and I know that this conference has been dedicated to the issue of justice for women. And I wanted to talk about the intersection of international criminal law and the protection of women in the most dangerous and violent situations that humankind faces. And that's generally during armed conflict, international conflict, and civil wars, where from time out of mind, even though women may not have been combatants, they've often suffered the greatest during those conflicts, because often the conflicts end up being directed not at the combatants, but at the civilian populations that are associated with the different sides in the conflict. International law developed on all continents and in all traditions, based upon the idea of protection of the innocent. The Holy Quran said to kill one person is to kill all of mankind. And in every tradition, there are rules and norms that when one fights against other fighters. And if one does that honorably, it is not a crime. But one directs violence against people that have surrendered or prisoners, and certainly against civilians. That is a crime, and that is a wrong. At the international level, that's been recognized through conventions, the so-called Geneva Conventions, also conventions that were negotiated in The Hague, in the Netherlands, and in which all countries in the world, the Geneva Conventions of 1949, every country is a party to those conventions, and generally set down rules for conflict. They're not about what we'd like to maybe see, prevention of the conflict, but about protection of people when conflict happens. And there are certain examples where conduct directly is focused on injuring the innocent, that we have crimes, as they call them in the Geneva Convention, grave breaches that become international crimes. And as a rule, those can be prosecuted at the national level in every country that's ratified the the Geneva Conventions, or they can be prosecuted at the international level by a court established by a group of states or by the UN or whatever, on the basis of a treaty or on the basis of that organization's charter. They can apply that law. And the first real example of that we had in the modern era was after World War II, when the victorious Allies established the Nuremberg Tribunal, where judges from Russia and France and the United Kingdom and the United States tried the former leaders of Nazi Germany. And they tried them for war crimes. But they also tried them under new law that had developed by international custom, and that included so-called crimes against humanity. And crimes against humanity are crimes in which there's intentional attacks on the civilian population. That whole area of crimes against humanity has been expanded to include crimes that occur when there's not a war, crimes that occur such as post-election violence, which we've seen in many countries, where if there's organized violence against people, innocent individuals, those can be crimes against humanity. Additionally, after Nuremberg, the world came together to write a genocide convention, which, of course, at Nuremberg, they faced the fact that the Nazis had been involved in mass killing, the attempt to destroy the entire Jewish people, killing about 70% of the Jews in Europe, some 6 million, but it also targeted other minorities as well. And a convention was written that said whether it's in a war or not a war, if you intentionally seek to destroy a group in whole or significant part, a religious group, a national group, an ethnic group, then that's the crime of genocide. So those three kinds of crimes are what we deal with at the international level. And it's the crimes that were given by the UN Security Council to the International Criminal Tribunal, which sat here in Arusha, with offices as well in Kigali, to try those responsible for the genocide, crimes against humanity, and war crimes committed in Rwanda in 1994. The most prominent overall crime was the genocide of the Tutsis, killing at least 500,000 of the Tutsi population, probably again about 70% of the Tutsi population of Rwanda during a period of only 100 days. But there were also crimes against humanity where Hutu moderates who would have protected Tutsi or would have observed the peace that had been signed by the Tutsi-led RPF, Rwandan Patriotic Force, were those people not on the basis of their ethnicity but their political position were attacked, and those were crimes against humanity. And there was also war crimes in Rwanda in the sense that part of the motivation, as you heard, I prosecuted the media trial in the media on Radio Televisión Libre de Mil Colín, which was not television, it was radio, an FM radio station. Tutsis were targeted as complicity, les complices, because they were perceived to be allies of the revolution, of the Rwandan Patriotic Front, which was Tutsi-led, and they were going to come in and take over Rwanda. They were, of course, Rwandan exiles, and then they would view every Tutsi would be an ally. He would be one of their soldiers. He would, as we say, a fifth columnist, and he would kill his local Hutu neighbors. So better to kill him first than to allow him to do that. So there was that motivation, trying to understand why people would do this. But that kind of thing is a war crime. If you attack civilians because you think they support one side or another, they're not. That's not allowed under war. You can't attack people because of their political views. If they actually take up arms, you can take them as prisoners or engage them in a battle, but you can't kill them. And so there was war crimes there as well. And as people may want to discuss, and as the defense would always point out, war crimes as well committed by the Rwandan Patriotic Front in the course of fighting that conflict. That's what we did here at the International Criminal Tribunal for Rwanda, which was established in '94 and really got going in about 1997. And I served here between 2001 and 2007 as a senior trial attorney, which is to be the leader of a prosecution team, which I was in the media case and several other cases. And then under the prosecutor, under Chief Prosecutor Hassan Jallow, one of my best friends and a great African jurist from Gambia, I was then appointed Chief of Prosecutions for 2 years, which didn't make me the Chief Prosecutor. I made me essentially his man, his leader for the trials. So I then supervised the 12 trial teams that we had, including the one that in the Military II case in which Matthias was representing one of the defendants. And I would go into court sometimes and question witnesses, et cetera, or make arguments. But we're here today, however, to talk about crimes against women specifically. And I don't want to say that I don't want to focus exclusively on sexual crimes, but that is where the law has needed to confront the violence against women most directly. From time out of mind, women have been subjected to horrible crimes of sexual violence during and following every conflict, generally ignored in peace treaties, in any efforts to achieve justice or to repair injury. Certainly in World War II, German women in particular were subjected, as their country was being defeated, to horrendous sexual violence by all sides, but in particular by Russian forces that invaded from the east. And no one talked about that at Nuremberg. The Geneva Conventions, which started being negotiated in 1864, when the 1949 conventions were negotiated, which were the most comprehensive ever, and the ones that have, as I said, been ratified by every country. Among grave breaches, they criminalize and say every country should criminalize attacks on human dignity. That was used by prosecutors thereafter to prosecute rape. But the word rape does not appear. The word rape against women or violence against women doesn't appear. There are sections in the humanitarian parts of the convention that talk about protection of women and children, et cetera, during conflict, but they don't explicitly refer to rape. That was indeed an oversight. Many, certainly of my feminist friends, would say, in using those terms, it was almost to suggest that it was the dignity of the man that was being violated by the rape of his partner, in a way, because you didn't talk about the victim. However, by 1977, when the world came together in Geneva to negotiate additional protocols, then it was made quite explicit that both in international conflict and in civil wars, non-international conflict, crimes against women were war crimes. And clearly, as the law of crimes against humanity was developed and applied, the crimes of sexual violence were included amongst explicitly the crime of rape, eventually also the crime of sexual slavery, and then in the list of crimes against humanity, there's a crime that's called other inhumane acts, and that allows inhumane acts that you didn't list but are at least as serious to also be prosecuted. That takes us to the Rwanda Tribunal and the crimes that we saw in Rwanda. And they were certainly written about by the commentators the historians that began to write about Rwanda, and the journalists and others. But it was clear to most people that had looked at the situation that there was, of course, the mass killing of Tutsi men, women, and children. But there was also the mass rape of Tutsi women prior to their being murdered, sometimes leaving them very injured in almost an example to others. This is what we will do to these people. And if you look at the hate propaganda that I was prosecuting in the media case, the RTLM radio broadcasts, and particularly the publications. We prosecuted also the editor-in-chief of a magazine called Kangura, which in Kinyarwanda means wake up. And there were these horrendous sexist cartoons in which Tutsi women were displayed as voluptuous femme fatale, as women who were basically conspiring to destroy Hutu manhood. And thus, when you see cases like one of the last trials in the tribunal, a very long trial, included a woman defendant. Pauline Nehemiah Shihoko was the Minister of Women's and Gender Affairs. And she was a Hutu and a leader of her party, the President's Party, and from the Butare area, the area of the National University. She was alleged to have incited the rape of Tutsi women by Hutu men, and really viewed them as an enemy. Unfortunately, however, when the tribunal began its first case, the first case that it had, and as these tribunals begin their work, the challenge is who they're going to get in custody. An arrest occurred in Zambia of one of the mayors of a commune in Rwanda, Jean-Paul Akayesu. He was actually in the opposition party and perhaps was not an initial leader in the genocide, was, as we would say, a Johnny-come-lately in a way to the genocide, but he was the first person that the tribunal had on trial. And he was alleged to have gathered, getting the instructions from on high that you needed to kill all the Tutsis, to have gathered the men together in his communal hall. And there are, in Rwanda is a country with some 200 communes, 200 towns, each with a burgmestre, and he was the burgmestre in one of them, in Taba, in an area west and south of the national capital, and incited them, people, with the benefit of the military that was sending some forces, and with the militia, the youth militia, to kill the Tutsis. And it's alleged that in some cases Tutsi women were brought to the city hall, and he encouraged the men to rape them. You need to know, you want to remember his exact quote according to the witnesses, but you need to taste a Tutsi woman, women who were then raped and and killed thereafter. He was charged with genocide and crimes against humanity for intentional destruction of the Tutsi people and for crimes against humanity for extermination and murder of Tutsi people, but not for rape. And in the course of the trial, in which the trials here, if you've seen or pictures of the trials or witnessed them, there were 3 judges in each case that sat as a trial chamber. And they came from 3 different countries. They were Francophone and Anglophone. Sometimes they were from countries where one of those languages was their second language. In the Akayesu case, the chair and the president of the tribunal was Judge Leti Kama, jurist from Senegal. Then there was Leonard Aspergen, a judge from Sweden, and Nabi Pillay, who you probably know of, from South Africa, who'd been briefly on the South African Supreme Court before Nelson Mandela nominated her for this court, a South African national with a heritage from India. And during the course of that trial, women were testifying, and they were describing what I just said. And the judges said, "Prosecutor, why don't we see an allegation of rape in this case? You need to reinvestigate." Now, this is a case of the prosecutor being asleep at the switch, in my view, and not having put this in at the beginning. But the judges took the initiative, and they adjourned the trial for several months and asked the prosecutor to investigate and look at amending the charge. And the prosecutors did that. They amended the charge and included rape as a crime against humanity in that case. And they presented that to the judges. Interestingly, the judges, when they handed down their convictions, which occurred in September of 1998, in that case, the judges here in Arusha rendered the first judgment in the history of the world for the crime of genocide. It would come to us from the Genocide Convention of 1948. Never before had there been such a conviction, not even for the Nazi Holocaust, because that happened before the convention. But interestingly, in the genocide, they said, according to the Genocide Convention, you can commit genocide in different ways. You can commit genocide by killing people. You can also commit genocide by causing serious mental or physical harm. What we see was done with the women here was an effort to destroy the group by humiliating and destroying the women. And even if the women weren't dead at the end, that was such an act of destruction, of physical harm, that we find that the sexual violence in and of itself is sufficient as an act to be genocide. Well, that's very historic. When they got to rape, they did something else. Of course, when you deal with rape, if you know your national criminal code, there are elements of rape, and these can be embarrassing to talk about. Some places talk about penetration, some talk about this and that, et cetera. And increasingly modern laws make that much broader than classical sexual intercourse. It includes a lot of other things. And they took, of course, the broadest view of it, though, of course, the most horrible sexual violence occurred in each of these cases. But one of the other things that generally has to be proven in a rape case is that it was done without the consent of the victim. So the defense could say, well, how could you say these women didn't volunteer and agree to it? Do you have any proof that they didn't consent? And the judges said that was nonsense. That given the overall physical context, given the equation of power, given hundreds of people waving machetes, and given the murder and the mayhem that one could see on the streets, and the ways in which women had been treated, who had been raped and killed, the context was such that proving intent or proving non-consent was not required. One could find that, infer that absence of consent from the overall context. So that was an historic judgment. Frankly, it took some time in the Yugoslavia Tribunal to also convict for rape as both a war crime and as a crime against humanity. And there was some debate on that question about the non-consent. But eventually, the rule that had been established in the trial of Akiyesu here in Arusha prevailed. In 2001, the Yugoslavia Tribunal also rendered, as I said, a judgment in rape regarding women who were raped in essentially detention camps in the former Yugoslavia. Frankly, that got more attention because it was in Europe than what happened here. And press would say it's the first time it ever happened. Well, it had happened here 3 years earlier. So thereafter, we were dealing with our cases, and it wasn't here at Arusha. Eventually, we had a total of 93 people that were charged, indicted by the International Criminal Tribunal for Rwanda. And understand the relationship between Rwanda and the court. Rwanda had its own national system. The RPF had won the war and lost the genocide. The Tutsi-led army took over the country, defeating a government that had made genocide part of its policy, in which the military, the political leaders, the economic leaders, the clergy leaders, the territorial administrators, to more or less one extent or another, had all been involved in what they considered this civil defense of killing the Tutsis. They would say to prevent the Tutsi army from taking the country. It was as if the Tutsis were hostages. If you keep coming, your brothers, sisters, mothers, and sons will be dead. And 70% of them were dead, though they took over the country, and they wanted very much to have justice in those cases. And the Rwandans have proceeded to try thousands of people for the genocide in their own courts. Eventually, they had more than 100,000 people in jail, including some that they brought back from the Congo. And they tried them, because it wasn't possible to try them in a normal court, they tried them in community courts called gacaca, or justice on the grass, gacaca being a word for grass in Kinyarwanda. They did not have very many of the leaders. The leaders had gotten out of the country. There was a French intervention force that was sort of complicit with the genocidal government, to be frank, though it said it didn't realize how bad they were doing, and they did save some people. But they generally allowed the leaders to get out. And they went into Zaire. And many others went there initially and were in refugee camps, and some of them were brought back during the wars in the Congo, in which Rwanda has been. We can talk about that too if you wish, but I mean, obviously involved there in crimes, but also in bringing back many of the Hutu extremists who were involved. But they didn't, most of the perpetrators had money, and they went off to other countries. So the tribunal, I mentioned that Akiyesu was arrested in Zambia. The tribunal was created under a resolution of the UN Security Council. Back when the UN Security Council, when Russia and China and the US could all agree on something, they agreed on this, gave it full Chapter 7 powers, which are powers under the UN Charter that says when the Security Council acts in the interests of peace and justice, its resolutions are binding on all states. Almost becomes a world government then. And all states are compelled to do it. Now, many times states don't comply. And sometimes there's geopolitics involved and you need a lot of leverage. But the extremists who were responsible for the genocide in Rwanda didn't have a lot of friends in the world. And they ran off to like 26 different countries. And the tribunal was successful in tracking them and bringing them to Arusha. We can talk about that at some time because it was an intense effort, and in some cases it took many, many years to get some of the senior perpetrators. And you know, I won't go into the history of the ICTR to a great extent, but except on the sexual violence to say that many people were critical of the Rwanda Tribunal. women's leaders in particular, saying, well, Akayesu is a great thing, but you didn't follow it up with many of the other cases. And it was often difficult to prove the direct involvement of these senior leaders, people who'd been Minister of Education or Minister of Foreign Affairs. What role did they have in the sexual violence? The Akayesu case had involved him actually being on the ground in the communal hall saying, go taste those Tutsi women. He was right there. But the ministers were in Kigali, or as Kigali fell, they were in other places where the government moved to. And how could you say that they were responsible? And the military was certainly involved in some of the rapes, but they were fighting the RPF at the same time, though they often provided reinforcement and assistance in breaking down doors. I mean, you know, if you've been to Rwanda, you will know there were churches like the one at Nyamata where 10,000 people were in this giant sanctuary, and they had steel doors on the churches, and the military came with grenades and broke the steel doors, and then the Interahamwe came in and proceeded to hack to death those 10,000 people. There were 7 survivors in the Nyamata church, and if you go there today, you'll see it's a high roof. Roof is 5 meters above the surface, but there's blood all over the roof. I mean, it was just blood all over the Virgin Mary and over the altar cloth, et cetera, what happened there. But they wouldn't have gotten in but for the military's support. So that, you had that kind of crime scene, but how could you say that the minister or the general was responsible? And that was a challenge in many of our cases, because we did benefit at the international level from something called command responsibility, which comes to us from Nuremberg, when it comes to high-level people and their responsibility for what happened down below. Traditionally, before Nuremberg, war crimes prosecutions, and in some countries, are still only about prosecuting a few low-level soldiers, saying these guys are renegades, they're bad apples, we're ashamed of them. They went off and did these things. But oh no, we didn't intend that to happen at all. And we know in many of these situations, the leaders do intend that to happen. But proving it and having an order saying, go rape the women, you're not going to see that order. And in international law, we've developed the idea of command responsibility, that if you're in charge of a group, and it could be military, usually is, or you can be a political leader with responsibility for the military, or you can even be in a civil organization where people can get fired for stepping out of line or doing the wrong thing. If you have effective control of an organization, and you know that people below you are doing horrible things, and you fail to prevent that or to punish them afterwards, you're guilty, as if you did it yourself. Okay. Handy. Defense hates that. You know, like, why can you say you didn't? Clean fingernails. Never got near there. Never wanted these horrible things to happen, but never did anything about it and knew it was going on. So we have that. Now, sometimes that doesn't work because the person who you want to hold responsible isn't the big chief. He's somebody that's doing other things. He's providing the fuel so that the killers can get to the site. He's doing the speeches telling them that these people are enemy and that they're going to kill you in your own beds if you don't kill them first. They're doing other things, and they're not in charge. But, you know, their words or their actions are helping the crime be committed. So international law of the kind that I practice is always complicated by what we call linkage. If you follow the experience of the ICC, for instance, they've had some very big cases in Africa. They had the case against President Gbagbo in Cote d'Ivoire. They had the case against then finance minister, but later president, and then government minister and later President Kenyatta and Ruto in regard to the post-election violence in Kenya in 2008 and 9. They lost those cases. Not because there weren't 1,000 people dead on a political or ethnic basis, but because they couldn't show that those men were responsible for what for what happened. So that's often the challenge at the international level. And we had difficulty at the Rwanda Tribunal proving that responsibility. On the other hand, as the cases went forward, eventually the judges became more open to using, for instance, command responsibility. In the Military One case, Military One involved, among the 4 defendants, Colonel Bagasora, Theoneste Bagasora, who was the chief of staff of the army of Rwanda and was effectively the leader of Rwanda, even though he was only a colonel during the genocide. And his forces were involved all over the country in supporting the rape and murder of Tutsis. In the Military One case, on trial and appeal, Bagasora was convicted, amongst other things, for rape, for having, through his actions, command responsibility, and rather his inaction to do anything to discipline or to take any action against his men for committing these crimes. He was responsible for that crime. He got a life sentence in Arusha. When it went to The Hague on appeal, the judges said, well, he's only indirectly responsible, so they actually sentenced him to only 35 years. And he might have been released by now, but for the fact that he died about 2 years ago. In any case, that was an important step. Another thing that occurred that was perhaps a little more controversial is another way that we tried to hold people responsible from a distance is through what we call joint criminal enterprise, JCE. I don't know how many of you practice criminal law. In many countries, they have laws about conspiracies, conspiration, groups of people that come together to do crimes. And as the law was being developed at the tribunals based upon the laws of nations and based on these treaties, and dealing with the fact that these crimes were committed not like an ordinary crime, not like a robbery on the street, but by organizations where different people would perform different roles. And each of those roles contributed to the killing, but many times the people who committed those crimes never got near the crime scene. Well, they're responsible because without those actions, you wouldn't have the crime committed. So how do you hold people responsible? Well, they came up with the idea that there were really sort of 3 ways that a person can be held responsible through joint criminal action. One is if you enter into a group and you share an intent. I share an intent to commit a crime. Or let's say you and I want to rob a bank, and I'm going to drive the getaway car, and you're going to go into the bank. We made a deal, and so even though I don't pull the gun, even though I don't walk into the bank, I have intended a robbery of a bank, and so I'm guilty of the robbery of the bank by driving a guy to this place and driving him away. There's also a form of joint criminal enterprise where you're part of a big organization, like a prison camp, and everybody's a cog. That's called joint criminal enterprise in the 2nd degree. But there's also one that's called foreseeability, and that's also comparable to the bank situation. You say, for heaven's sakes, don't kill anybody in the bank. I don't want to face murder or anything. Just get the money. Threaten them. Wave the pistol. Pound on the table. And the guy gets the loot and comes running back in. And he said, sorry, I had to kill the teller. Are you guilty of murder? And under most domestic laws, under a thing called the Felony Murder Act, if you intend a felony and a murder results, you're guilty of the murder. Some states don't have that. Well, a joint criminal enterprise is like that. Suppose you're in a conflict and you're saying, our soldiers don't have any food. You go into that farm and you steal all the cows. And you bring them out here and we'll take them and butcher them and use them to feed the men. Well, so that would be, in war crime, the crime of pillage. But most people don't want their cows to be stolen. And they don't want their own families to starve. And the guys that are doing it are all armed with machetes or guns, Well, what do you think is going to happen? Somebody's going to resist, somebody may be injured or killed. Well, that was foreseeable. And so under those circumstances, you're guilty of, you intended pillage, but you got murder. That can happen. Well, we also have that at the international level. It's controversial. One German judge said, joint criminal enterprise, you know what that means, JCE, just convict everybody. So quite negative attitudes about it. On the other hand, in one of the last trials here, one of the leaders of the president's political party in Rwanda had been involved very actively in supporting the genocide all over the country. And they clearly intended the destruction of the Tutsi people. Well, that's a pretty awful thing to intend. So they're guilty of genocide because that happened. But they also charged them with rape as a crime against humanity. And they did that on the basis of, well, you may have only wanted to kill them, but you guys have been running all this propaganda about how these Tutsi women are the femme fatale. They're the people that are stealing the blood of Hutu men. And you look at all of that, and then you see what's happening all over the country. You see these examples of stakes through people's sexual organs that are dead on the road. You know what's happening. You've traveled, your government has moved from here to here to here to here. You've seen the international accounts. You've seen the denunciations by the Red Cross. This is foreseeable. And in that case, the Karamira case, the judges held those men responsible for rape as a foreseeable consequence of their intended killing of the Tutsi people. Anyway, that's the history of the Rwanda Tribunal. Later on, as you heard, I went over and became the chief prosecutor of Sierra Leone, which was not a court not created by the Security Council, but a court created an agreement by the government. It was one party in a civil war fought in the West African country of Sierra Leone and the United Nations. And it was in many ways, I love being in Arusha, and Arusha had employees in the court from more than 100 countries. But it was a UN court. There frankly were not many Rwandans employed outside translation. On the other hand, the Sierra Leone, and we tried our cases in Arusha, 1,000 kilometers really, 800 kilometers, I suppose, depending how direct you drive it, from here to Kigali. Long way away, whole different culture, whole different world. That was a drawback. In the Sierra Leone court, we tried the cases in Freetown, within sight of where Freetown, the city, was effectively raped in January of '99, taken, hundreds of women raped, thousands of people taken off and enslaved, horrendous crimes, which you might have seen on CNN at the time. We were right there. The exception was with the Charles Taylor case when we had him arrested. The African leaders, Obasanjo of Nigeria and President Sirleaf of Liberia, both said, we're afraid if you try Taylor in Freetown, there could be violence in the area, hostages taken, that kind of thing. We were required to try to move that case. It was tried originally to move it to Arusha, but Arusha in that era was very busy with trials, and it eventually was moved to The Hague to be tried in the courtrooms of the new International Criminal Court that didn't have any cases yet. I came on as the third prosecutor in January of 2007 as we were finishing the trials of the leaders on the ground in Sierra Leone, and a few months before we were to begin the trial against Charles Taylor. And we were dealing with a quite different kind of situation in Sierra Leone, where there was not a genocide. There was no ethnic motivation in the crimes. There wasn't a religious motivation. If you know Sierra Leone and the traditions of coastal West Africa, there's generally extreme amount of friendship and common life between communities of different religions. When we did outreach meeting, every meeting began with a Muslim prayer and a Christian prayer. There was no there was no religious, these are extremists, jihadis, none of that appeared in it. It really seemed to be, there were political leaders like Foday Senko who argued for political change, but it was basically about theft of resources. It was like we'd say in the old days, brigandage, and getting to the diamonds of Sierra Leone and controlling the wealth of the country. What was it all about? And because there really wasn't any motivation, there weren't that many adults who wanted to fight in the conflict. The modus operandi, beginning with Charles Taylor's invasion of Liberia at the end of 1989 from next door from Cote d'Ivoire, was to recruit children to march into villages and begin killing people in the most brutal and horrendous ways, disemboweling people and using their intestines for roadblocks, for instance. And then marching other people forward and saying, we're going to chop off your hand. Should it be long sleeves or short sleeves, etc. The horrendous violence. And who would do this? Well, in those towns you'd say, you know, young kids, you want to get your hand chopped off, or you want to join us? And they would recruit young people, young boys, also young girls, who then had to also be sex slaves. And they would use them in the next town to commit these crimes. And they would, you know, give them gunpowder mixed with other kinds of dope to snort, and give them names like Rambo. And that was, you know, of course, they would be, just in terms of the effect and the horror and the shock and the trauma that visited on them as a child. They were victims, but of course they then proceeded to do horrible things to others, using that as a tool. And so that kind of thing occurred. Well, as I said, we had sexual slavery, people being recruited as sex slaves. You had mass rape. It's been estimated that as many as a third of the women and girls within areas taken by the rebels in Sierra Leone were sexually violated in one way or another. Now, deaths, in every conflict, there tends to be some exaggeration of deaths. Deaths are at least 50,000. Amputations are maybe 10,000. A lot of people die, bleed out. Many people survive. And if you go to Freetown today, you'll see the 2,000 or 3,000 surviving amputees. Good friends that I have and support their different programs, and still go back, was just there last year. But sexual violence was probably the largest crime. And so in our cases, and we charged the leadership of the three movements, armed movements, one, the Revolutionary United Front, the RUF, who was really the nastiest group. Taylor, next door from Liberia, largely used them as his guys to get to the diamonds. There was also the Armed Forces Revolutionary Council, which was a junta that took over the country in '97 and invited the RUF to rule with it, and rule the country for 9 months, in which every Sierra Leonean would refer to as the worst government ever, a government that survived entirely by pillaging its people. With a West African peacekeeping force led by Nigeria, but including soldiers from other places, and with a civil defense force that was recruited among the tribes of the South, they were driven out of power in February and March of '98. But they went into the bush and became even more brutal and launched operations with names like No Living Thing or Operation Spare No Soul. And certainly there was also Operation Pay Yourself, which is an open direction to engage in pillage. As I said, there was this third group of generally young men that were recruited called the Kamajors and the Mendi people. Sierra Leone is a country that is on the climate changes, but has both forested areas and savanna areas. There's some division between the Temne people of the north and the Mendi people of the south. And in the south, in the Mendi areas, you had these hunting societies traditionally for young men to be trained to hunt the wild animals to the extent that there are still wild animals given climate change, economics, and everything else. But they were recruited, often as children, to fight against the rebels. And they took initiations to make themselves invulnerable to bullets, and were generally viewed as not committing a lot of sexual violence, though we have examples of it. And they also did some horrible things to women who'd been bushwives or sexual slaves at the other side, and also just killed everybody in some of the villages that were viewed as pro-rebel. And so we tried the leaders of that group too, even though they fought on the right side. And then, of course, had Charles Taylor from next door, who was arrested in Nigeria in 2006, tried for his responsibility for the crimes in Sierra Leone committed by the RUF. Each of the cases, nobody pleaded guilty. Each of the cases involved charges of rape as a war crime, rape as a crime against humanity. Also, for the first time in history, sexual slavery as a war crime and crime against humanity. But we also saw there was something else going on here, and that was that women were being conscripted as wives, as I said, bushwives of Tutsi men, there I go to the wrong area, of RUF and AFRC commanders, and were essentially conscripted into the role as the consort of a rebel leader. And obviously that included the sex part, but that also included cooking and assisting and running messages for and doing everything for the husband. And one of the things that then happened is after the end of the conflict, these women were viewed as traitors by their own people because they'd been the queen to the evil king. And so they couldn't go home. Or they could stay with the rebel, presuming he's not prosecuted or anything like that, can live with him in perhaps squalor and care for his needs. And so we said, this is really another crime. This is forced marriage. Well, that wasn't in the book, so to speak, but we said that's an inhumane act. And we had an expert witness, a woman you may be familiar with, Zainab Bangura, who was a community activist in Sierra Leone. She had become, when there was a change of power in Sierra Leone, and this was after she was a witness in our case, she became foreign minister of the country. Later, I helped her be appointed as the Secretary General's special representative for sexual violence in armed conflict, position she served in, and chaired the big conference in London with Angelina Jolie and William Hague, et cetera. And she now is the Director General in Nairobi of the United Nations in Nairobi. Good candidate for Secretary General if I have a vote. I don't. Anyway, but she did a great report for us. She surveyed 200 women and showed the evidence of all of the experiences that they had through the process of forced marriage. And I don't want to credit myself. This was begun before I arrived by one of our good trial attorneys, a woman by the name of Boitia Stevens from Sierra Leone. She developed the case. At the trial, the first time we tried it, the judges ruled against us 2-1, with one judge saying, no, this is a crime. The other two say, no. It's the sexual slavery. You're just heaping on. You're just charging. You get it in sexual slavery. Why do you need this too? Well, we appealed that. I remember there was a fight in my office, and I said, no, we're going to appeal it. We're going to win this, and we did. We won it on appeal. And then in the last case, the RUF case, each of the 3 defendants were convicted of forced marriage as a crime against humanity. But it was an example of how you use the law. Many would say you're stretching the law, but no, the law provides that if it's an act that has horrible, inhumane aspects to it, you can expand and define those. And if it's equal to the things you're already prosecuting, I mean, who knows what horrors we may face in the future. You can't write them all down today. If they're equivalent, they should be included. Well, anyway, that's an example of I think the success in this area. And of course, this is at the international level. And when I talk about international cases, I always say that international cases really should only happen when the national system doesn't do the job. And when the ICC was created, that was a key element. The ICC is a complementary court. It's a court of last resort. The national system always has first shot, so to speak, to do the case. And ideally, if the ICC were more powerful, more countries might be doing that. Some do. There are examples of nationals doing national systems prosecuting these cases. Now but relatively few where there's sexual violence prosecuted. Hard cases to develop. People are, in terms of cases where you're relying on confessions, which unfortunately is often the case, people confess to almost everything other than rape. So you don't have those charges. And in most countries, it's very hard to prosecute your own. That's what the ICC depends on. Kenya, instead of having their case in The Hague, should have had, as Judge Waki, great judge from Kenya, said, a national tribunal, and the cases would have been prosecuted there. Instead of The Hague, and if it's happening at The Hague, it's easy for people to say that's a bunch of foreigners doing it. Much better that it happened at the national level. Well, both the victims and the perpetrators said, don't be vague, take it to The Hague. And that was a mistake for the victims, I think, to do that. And because it was easy to demonize the court, hard to get people to cooperate, and the court wasn't very powerful on the ground in terms of protecting witnesses and everything else. Now I'm not making any judgment about who's guilty or not. These cases still have to be proved, and defense needs to be very effective in these cases, or the wrong people will be convicted. So, but in any case, what didn't happen at the national level? In Congo, for instance, cases do happen at the national level, usually relatively low-level people, but in the military system, but include people who are in the Congolese military convicted of rape. Many times they're people who belong to other armed groups that have been incorporated through peace processes in the Congolese military and aren't really in effective control. But there are cases. I'm very close to Dr. Mukwege, who heads Panzi Hospital in Bukavu, a real hero of mine, and who won the Nobel Prize, and together with Nadia Murad, the Yazidi victim from Iraq, about 6 years ago. Actually, my daughter works in Bukavu and elsewhere for Dr. Mukwege, so I should say that. I was just with him last week in Washington, and he was describing how, in a particular, if you know Panzi Hospital, it's a regional tertiary care hospital, but it specialized in victims of rape and sexual violence. And the conflict in Congo, beginning with the invasion of Congo by Rwanda and Uganda in '96, and continuing to this day, including by elements that were involved in the RPF, and also in the Hutu extremists who were responsible for the genocide, has had horrendous violence in the kibbutz for 30 years. Some call it Africa's, and because of the intervention in the Second War, 6 different countries sending armies, it's Africa's World War. And one speaks of 5 to 6 million people dying, not all of direct violence, many from starvation and disease that accompany the conflict. But sexual violence has been an enormous part of the violence. And Dr. Mukwege's clinic in Bukavu had, his specialty is dealing with women that have had rape and that have been horribly injured because of the brutality of these crimes, which often then have these secondary conditions like fistulas, which are openings between various parts of the body, which can become infected and cause horrible disease and death. And he's dealt with some survivors of sexual violence that have been raped as many as 3 times. I had this patient 3 years ago when they were raped. I have him again. I don't think this person will ever hold urine again because their condition is so bad. So all of these horrors are visited. He also has behind the hospital Maison Dorcas, where he works with the women in terms of the trauma, in terms of finding jobs, and also allows them to meet with local magistrates and begin cases. And so these have resulted in scores of cases against the military perpetrators. One of the more horrible things that he experienced several years ago, where there were mass rapes occurring in the town of Kavumu, which is about 20 kilometers north of Bukavu on the west side of Lake Kivu. And he treated as many as 200 little girls for sexual violence. And there was evidence that and this may not have been so involved in conflict, there may have been some other aspects motivated, and I can talk about that if you wish, but he was horrendous. Well, it was possible with international assistance to convict those people who were responsible. It was an historic conviction in the military courts. And he said after that, for almost a year, he didn't have any juvenile sexual violence patients in the hospital. Of course, now, as you know, M23 has taken control of Bukavu, so he can't. The justice aspect of his treatment have basically been shut down, because that generally, though not completely, involves allegations against M23 forces. There's no question that despite all our efforts more generally to deal with these crimes at the international level, they continue to be committed with impunity. I'm one of the organizations that I helped found in the last 4 years is called OJA, Organization for Justice and Accountability in the Horn of Africa. And I don't want to get into details because everyone that works in the organization is in danger because of the work they do. But it was possible to train clinicians by satellite link during the conflict in Tigray, and they treated during the course of that conflict thousands of victims of sexual violence, and then in cooperation with Physicians for Human Rights, we've done 2 reports about the sexual violence, and the most horrendous aspect of it, and you may have seen it reported in The Guardian and elsewhere, was not just the sexual violence, but the ways that the crimes that were committed associated with it that clearly showed an intention to destroy the women's reproductive capacity. Hundreds of victims with nails and other foreign objects inserted into their bodies. In a few cases, even genocidal messages found in the uterus, when people then sought medical care a year or 2 later and had horrendous secondary infection, in some cases even cervical cancer. I met some of those victims in McKelly in March, and they were having dealt with these cases in all sorts of places. They were the most traumatized and injured of any survivors that I've seen in the world. No justice yet at all for that. And certainly if there's a conflict and by the way, I mean, the indication is almost all of the perpetrators are uniformed, not young renegades with guys with machetes and bandanas, and almost all of the rapes were gang rape. So not a situation in which we have solved the problem by any means. As someone who prosecutes after the fact, I have to admit to my own impotence in the face of this, recognizing that in an ideal world we would find the perpetrators and try them swiftly and surely, that we'd have the kind of impact that at least the military prosecutors achieved in the Kivus with the Kavumu rapes. But the system of international justice, of trying a few, sometimes many years after the crimes, has not sent a strong enough message of the importance of deterrence and of, to prevent these crimes in the first place. Keep in mind that the victims and survivors need more than prosecutions. They need extremely empathetic and intensive care and assistance, not only for the physical injury, but the emotional one. They certainly all that I speak to eloquently confirm that they saw in their perpetrators this desire to destroy them. And given the importance of the role that women play in communities and in their families, that is sadly an effective way to destroy communities and to displace people. And so these are crimes that are intended, they are orchestrated, supplied, directed, assisted by leaders in order for political or economic advantage. They're not crimes of crazy people running around doing things in the street. Mobs will do nasty things, yes, but mobs don't carry on for months and months and years. They don't wear uniforms. They're not subject to any kind of discipline, which should be part of the professionalism of military forces. So they are cases that deserve justice, and those that are responsible should be held to account, and that goes beyond punishing them. That goes to reparations for the victims, survivors. Interestingly, the Congolese system does have compensation. It's something like a payment that would amount to a few $100s in Congolese francs for every victim, and in more than 1,000 judgments, there's orders for reparations to the victims. There are no cases in which it's been paid. The government of DRC doesn't have the resources to pay it. So that's a big gap in terms of the justice process. But fundamentally, as we're talking about these cases and recognizing the difficulty of prosecuting and of developing cases against powerful individuals in any society, including mine, one can only expect so much. But the lesson of all of it, certainly from the international level, is that the main responsibility is at the national one, and that we need to do everything we can to reinforce justice at the national level so that international courts don't need to become involved. And the national systems can benefit from the experience, from the law, from the precedents that are created in this area, because in most countries recognize the supremacy of international law through their constitutions or through their legal systems, particularly in civil law countries. The law that's been established in all of these countries is the law of the world and can generally be applied by any competent court anywhere in the world, and most appropriately should be done at the national level. So that's I talked now for an hour and 15 minutes. Sorry to go on and on, but I think I have until 10:30, right? Is that the schedule? So I'm glad to answer questions. Yes, there, just on the left. State your name. Thank you. So just with the purple, you're waiting for a microphone. Our friend here, on my far left in the fourth row, was the first person I saw. And just state your name and where you're from.
Thank you very much for the presentation.
Mm-hmm.
My name is Brenda Kombo, and I'm from Kenya.
Okay.
So I really appreciate your comments on the complexity of the Kenya ICC cases.
Mm-hmm.
So I have two questions. One is, how do you respond to critiques that the ICC is essentially a tool of global power that not only disproportionately targets African states, but also has not been successful at addressing the socio-political and the economic issues that sort of drive some of this violence, especially against women in these contexts? And then the second question is that restorative justice is a really important value within most African contexts. And how do you think that the ICC and international criminal law in general can take a more restorative and less sort of retributive approach to justice, especially given that the ICC Trust Fund for Victims is quite underfunded, under-resourced? But what do you think might be some of the ways that this more restorative approach could be taken?
Okay.
Thank you.
Well, I mean, I think people heard the questions. I mean, the first one is the one on double standards, and obviously, you know, one can see in the international system in the ways in which sometimes powerful states often donate, you know, haven't entered the ICC. Russia, China, the U.S. aren't parties, as you know. 33 African countries, however, are. And the Security Council can refer cases, which they did on Libya and Sudan, but don't, you know, were blocked in the case of Syria and are expected to be blocked in other cases. And so one sees that it's not even-handed now. To be frank, it's become more even-handed. It's, you know, has arrest warrants for Netanyahu and Gallant now. It has proceeded with cases against Europeans in the Ukraine tribunal. You know, if you look at international justice all told, the number of people that have been charged in international tribunals in the last 30 years, almost half of them were from the former Yugoslavia. So it's a nature of the fact that the first cases that the ICC got involved in were cases in which generally, with the exception of Kenya, the African country referred the case. The ICC said, we can't do it, we want you to do it. It's a little bit unfair in that regard, but the overall criticism, I think, is valid, and one needs to, you know, step up and you know, provide other ways to deal with justice, and I'm always in favor of justice at the national level, and, you know, African solutions for African problems. We have the Malabo Protocol to establish a criminal division in the African court here in Arusha, signed 10 years ago. It has limits. It doesn't allow senior leaders to be prosecuted, and so far only one country in Africa, Angola, has accepted the jurisdiction of the court. I'm often a visitor to Addis and trying to deal with even establishing investigations in Africa, not to have investigations by Geneva, by the Human Rights Council, for instance. And was pleased to see that my good friend Mohamed Chande Othman, former Chief Justice of Tanzania and former Chief of Prosecutions, my predecessor here in Arusha, was appointed to lead a 7-person commission here in Tanzania regarding the post-election violence in this country a month or more ago. So I like to see those solutions at the national level, and you know, it's one of the you know, though, you know, being a prosecutor, you might imagine that my position when I'm facing a trial, and I mean, I've never run into a situation where the victims and the survivors did not want justice in that case. And when I deal with Sudan, for instance, and the victims in Sudan, they're frustrated not because the ICC has charged people in Sudan for the crimes. They're angry that they've only got one person arrested. They want more trials. They want Hamedi prosecuted yesterday, you know, for the crimes in Al-Fashir that we've seen, et cetera. And so they don't think it's effective enough for them. Of course, if it were, it'd be trying more people for these crimes. So, you know, I think the critique is valid, but every case involves the crime, and if an individual is charged for the crime, and it's a question of is there proof? Is it a fair prosecution? Are they effectively defended? Are the victims heard in that case? This week, we were celebrating the 80th anniversary of the opening of the Nuremberg trial. The Nuremberg trial was a classic example of victor's justice. And the Allies in Europe committed crimes, just like by the rape by the Russians and the destruction of civilian neighborhoods where there were no military targets in Dresden and Hamburg by the Brits and the Americans. Those weren't tried. The murder of Polish prisoners by the Russians wasn't tried. So it was one-sided justice. But and when it was tried, the chief prosecutor said, "We know this is one-sided, but we're not going to convict them, on our evidence. We're going to use their documents, their evidence. We could shoot these guys basically, but we're going to have a fair trial and see whether they're truly responsible." And in the great trial at Nuremberg, there were 22 on trial, and 3 of them were acquitted. So you deal with the case that's in front of you, and you do what's fair and right in that case, and that's what the victim, the survivor, expects. But as you're quite right, the system doesn't approach every case equally, but it does establish a law that can potentially be used against others. One of the things that's happened in recent years in places where the ICC can't go is universal jurisdiction, which is courts in third countries that are prosecuting crimes committed elsewhere because nobody else will do it, and because these are crimes against all of humankind. Now, you have European courts trying torturers from Syria as a result. Argentina has stepped up to the bat, and it's trying victims from or providing justice for victims from Myanmar and Southeast Asia, et cetera, in its courts. I'd like to see African countries do that, and there's 4 prosecutors, Uganda, Kenya, South Africa, and Mauritius, that have formed a group to look at the potential of doing cases out of Sudan, et cetera. Now, how popular that would be, how much resources they would have to do them, but to the extent that survivors are helping build the evidence, that would be a whole lot better than having those cases tried in The Hague or in some European court. So anyway, that's in terms of justice. On criminal justice, such as it is, recognizing always that criminal justice, the business of putting somebody on trial and sending them to jail, doesn't restore the community, doesn't restore the victim, survivor. And obviously, if there are other tools for doing that, I want to see them exercised. Frankly, in the cases that I've had here, well, I can talk about the Sierra Leone ones. My friends, the amputees, they would be cheering, when we won these convictions, and in the end they would say, well, we can't eat judgments, et cetera. What are we going to do? And we would seek other ways, other assistance, other programs. We established a victim reparations program there. The community did. International donors came in and contributed around $8 million, nowhere near sufficient to cover it. Senator, the UN, like the experience of the Trust Fund for Victims, but obviously, to the extent we can go after corporations, which has recently happened in a few cases, victims from Tigray that have sued Facebook, now known as Meta, for incitement of the genocide in Tigray that killed particular victims, cases that are now being pursued against the oil company Lundin and its executives in Sweden for the crimes they committed in Congo in Sudan in 97 to 2002. Has the potential to provide, tens of millions of dollars in recovery, et cetera. And we often have arms dealers and minerals dealers, et cetera, that are involved and that are benefiting from these crimes, and trying to get at those assets could get us some money that would exceed that's available from the charity of certain countries that are willing to invest in the Trust Fund for Victims, which is kind of a hard sell to get countries to put money in there, et cetera. So that can help achieve justice. Obviously, if one can develop a justice process in the country, on the grass, so to speak, that's better, that's to be preferred. I mean, we have the Rwandan experience of the Gacaca. Maybe, I don't know if we have any Rwandans here or people who discuss Gacaca. It had great advantages in that it was the community that decided. It did prioritize sort of confessions by perpetrators who would come in and say, I stole 2 cows. And then people would say, no, you killed a child. No, you did this, you did that. And eventually this community group of judges who were elected would make a decision. Usually they had a hard time often making the decision. They would split the difference in a way. It's sometimes hard to evaluate to it. And I know many survivors who weren't happy with the justice of the Gacaca. I know also it was a punitive system. The Gacaca was not a Truth and Reconciliation Commission. It had the ability to sentence people to up to 30 years in prison, and it did. In a great many cases, because by the time it had people in front of it, they'd already served 10 years. It was possible to say, we sentence you to the 10 years you've already served, and you're going to have to do some community service, build some houses or something, and they let the person out. And then survivors would say, we don't want that guy back here, et cetera, but you would have that. And then there were those who said that, because they started with 100,000, but they gathered information and eventually charged up to 1 million people in it. That some, you will hear Hutu survivors who say it was used as a tool to essentially marginalize that community and to say every adult Hutu in the country must be a criminal in a way. So but you always have these sorts of issues in the criminal justice process. I supported it, even though it didn't have lawyers. I thought it got closest to justice for the victims in those cases, but still less than ideal. So that was a design thing, of course, led by the government. But if one can develop a better system to do it nationally, that's good. The ICC doesn't have to get involved. In Colombia, for instance, the ICC stood off stage and said, Colombia, you negotiate a peace agreement. They wanted to make a deal where people could could confess and be freed, get essentially probation. The ICC prosecutor says, no, they have to get some penalty. And so eventually developed maxims that if people truly confessed, paid reparations, led you to where the bodies are buried, they could get a maximum of 8 years in house arrest. They also made sure that it included justice not just against the anti-government FARC, but also against the military, that it killed thousands of people as so-called false positives. And so they developed this justice project, this jurisdiction for peace, as it's called. And they're trying cases, and the ICC hasn't charged anybody. It's stayed off the stage. It's not perfect, but it's an example of it has a reparations commission, a property restitution commission. It has all sorts of things. It's a complex process, trying to meet the needs of the survivors after 3 decades of violence. And I want it to succeed, and hopefully it will. It has now rendered some of its first judgments. So anyway, if that can be done, that's best. Yes, back there with the black and white.
Thank you, Your Excellency. My name is the Advocate Veronica Johnny from Kigoma region.
What did you say where you're from?
Yes, from Kigoma region, Kigoma.
Okay, Kigoma. Okay.
Kigoma, yes.
Okay.
Your Excellency, thank you very much for your wonderful speech, for your wonderful presentation. It has been extremely useful to me as a student pursuing a master degree in international criminal justice. Your Excellency, we have all witnessed the global conflicts in Gaza, Syria, Afghanistan, Yemen, Somalia, Ethiopia, and other parts of the countries. And where the primary victims have been innocent women and the children, many of whom they have been subjected to sexual exploitation and abuse, but also mass killings. So my question now is, in your view and experience of working with this international criminal justice and maybe international criminal courts, why does the ICC, despite its mandate to take action against those responsible for these atrocities within the world, why are they delaying to take appropriate actions? Or sometimes they have been selective reacting in certain situations, but in case of Gaza, we have not seen any action have been taken by the court. Thank you.
Well, as I noted earlier, They did take action in Gaza. Of course, the court is facing a counterattack from the U.S., which is unjust and wrong by Trump on the Gaza case. But they, did charge Netanyahu and Gallant, and Netanyahu can't travel to Europe as a result of that. When he visited Washington to see Trump, he flew over Algeria and Morocco rather than go through Europe. And so it does have some effect on him, but not a lot. But the ICC is challenged. I mean, there's structural problems. I mean, first of all, there's jurisdiction, and then there's kind of a structural problem, and they're kind of inherent in this. It's a treaty-based court where it only has jurisdiction where a country has accepted it. And Syria is not a party. Ethiopia is not a party. Yemen is not a party. India is not a party. U.S., Pakistan, China, Russia, etc., are not parties to the ICC. It's a problem. Of course, as I noted, 33 countries in Africa are parties. Kenya, Uganda, Tanzania are parties. Rwanda is not. Burundi was, but quit. Congo, the Democratic Republic of Congo is, but Republic of Congo isn't. So it only has jurisdiction if the crime happens there. So people would often say to me, because I was so involved in Syria, where at least 500,000 died, and the worst atrocities of the 21st century there, really. 120,000 people still missing, having been tortured to death, and now in about 257 mass graves, and I'll be back next month for the 5th time since last December, trying to get justice there. Why didn't the ICC go there? And the answer is, no, Syria is not in the ICC. A resolution was up in the UN Security Council. 13 of the 15 countries voted for it, including the African countries. But Russia and China voted no, that was a veto, so ICC didn't have jurisdiction. So quite often the ICC can't go to these places. They can go to Palestine. Why? Because the UN voted that Palestine was a non-member state and determined that it was a state. And then Palestine, which doesn't have de facto control, of course, of all of Palestine, but under international law should have control of Gaza, East Jerusalem, and the West Bank, became a party of the ICC in 2015. So if a crime is committed on its territory, aka in Gaza, then it can send the case to the ICC, which it did. So that's why the ICC has jurisdiction there. It doesn't have jurisdiction over crimes committed in Israel, for instance, because Israel's not in the ICC, but the vast majority of what's happened has occurred in Gaza or in the West Bank. So that's what it depends on. The other thing is the ICC is a court with 18 judges. 6 of them are elected every 3 years, and they sit in as many. There are 2 groups of 3 judges that sit in trial chambers, so it can do 2 trials at once. When you deal with these kinds of cases, particularly political leaders, and when you deal with all the cultural factors and what's happening in countries, and you deal with the interpretation and the protection of witnesses and everything else, the cases go on for a very long time. The media trial that I tried here took 34 months. That was speedy. The Batari case, involving 6 accused, took 10 years to finish. Okay. Now, the ICC, as a result, in most of its trials, doesn't even deal with the big picture. It had 2 trials from the Congo where it dealt with 1 massacre on 1 day in 1 village. And so it was trying who was responsible. Now, did they get the right village and the right day? But each of these cases is so complicated, and people have very effective defense, like Matthias and other attorneys, which is appropriate. And many of the witnesses didn't wear watches, so they don't know the time of day when it happened. They get confused about one thing or another, and sometimes it's very difficult to prove that the sun came up in the east that day when you really put it on in a trial. So they are very difficult cases to try. And so there's only a handful of cases that can actually go to trial. And then, of course, you got the problem of state cooperation with making arrests. Netanyahu and Gallant are still free. Putin and the other 5 persons charged in Ukraine are free. The general in Myanmar is free. You know, they did manage to get President Duterte of Philippines because the current government didn't like him, and they turned him over to the ICC. So they do have a president, the former President Duterte, who was involved in allegedly killing several thousand people as part of their war on drugs. Just went out and shot people he thought were drug dealers or drug users. So he's going to potentially face trial. But many cases they don't get the guy that may be responsible. In Sudan, a case the ICC's had for 20 years now, they had one guy who surrendered. So they don't have President Bashir, they don't have the Minister of Defense, et cetera. And states really won't help them make the arrests. And of course, these guys are often places where the states can't reach. Well, that's why Uganda sent the LRA case. Kony wasn't even in Uganda at that point. He was in Congo, he was in CAR, et cetera. He was in South Sudan. And we still don't have Kony, though we did get his deputy, Ungwen, who surrendered to the U.S. force that was in the African Union counter-LRA operation and went to the Hague. So they don't get everybody. So you've got a real hit-and-miss sort of proposition there. Even if they're choosing absolutely the right cases, the ones you see are not going to be that emblematic necessarily. And the prosecutor has to evaluate. Since the office is established, they've had like 3,000 requests from civil society organizations. Please, please, please open a case here, etc. So there's a limit, and they have 77 investigators for the whole world. So fundamentally, the only way that it really works, if the states do the work, and it only comes in occasionally, and that it's so effective and so tough, people say, well, we'd rather do it right here than have it go to the Hague. You know, then it would work. But thus far, it's shown itself as pretty ineffective. And in some of its most senior level cases against government leaders, those are controversial cases, and I'm not going to opine on guilt or innocence. Bemba, Gbagbo, Ruto, Kenyatta, it lost. Okay. And it's generally only convicted rebel leaders so far. That's the people it's had. So it may have charged top guys. It just didn't get them either in custody or with the proof. So that's the challenge of that one. At the moment, I mean, the better approach is I'm on the committee with Fatou Bensouda, and we just named, I don't know if the person has yet accepted, the prosecutor of a special court for the Gambia. And the Gambia in transitional justice had a very good Truth and Reconciliation Commission, which was on television, and many of the perpetrators talked about what they did, et cetera, and the victims had a very good hearing. And perpetrators were forced to be examined by a very good defense lawyer who been a defense lawyer from the tribunals, the guy by the name of Fall, who was the chief counsel of the commission, would make sure the guy wouldn't just admit to one thing when he'd done 20. Really had it. And they then decided to have a special court, and there's an agreement that was negotiated between Gambia and ECOWAS to create a special court that would have jurisdiction to try international cases, including against President Jammeh himself. Jammeh, who has exile in Equatorial Guinea at the moment. Whether he'd be turned over to the court, we don't know, but there are other perpetrators. And so that court will have a mix of national and international judges. They won't get paid like they do in Arusha. They'll get paid according to the ECOWAS scale, and we'll see if the resources can be raised to do the court. But that will be justice in Banjul for no war, but for the crimes of a dictatorship, in which there's sexual violence, there's torture, there's perhaps 1,000 people killed. So it's not the biggest menu. But that approach is, I think, one of the more promising that's occurred now, and it will get most of the individuals that it's charged into custody, and it'll be done in trials that people can watch on television or visit the court and watch, and we'll see how it goes. Yes.
C'est moi. D'accord. D'accord. Merci beaucoup, Son Excellence, pour votre brillant exposé. Vous nous avez suffisamment éclairé sur le fonctionnement des juridictions internationales. Moi, je suis Nyamwego Zalissa, je suis du Burkina Faso. Mais ma question concerne le cas actuel du Soudan, parce que nous voyons que par jour, des milliers de femmes sont massacrées. Donc, ma question, c'est de savoir, est-ce que le cas du Soudan rentre dans le cadre du droit international? Est-ce que le Soudan peut être attaqué devant les juridictions internationales, notamment la Cour pénale internationale ou la Cour de la Haye? Et ensuite, je voulais savoir votre perception sur la situation. Est-ce que la communauté internationale peut intervenir pour le retour à la paix dans le cas du Soudan? Merci bien.
I think we'll take several questions. I think I understood that when I will get clarification on it. But let's take this gentleman here in the, we'll let the woman go first and then you're next, okay?
Thank you very much, Your Excellency. I have, this one? Yes. I have one question. You mentioned that most of these countries, most of the people they take before the court never plead guilty. And my question is, if they pleaded guilty, would it be a mitigating factor for their sentence, especially because depending on the crimes that they have committed, would you, as a prosecutor, consider it for them to get a lighter sentence? And then the other thing I would we have the discussion that you had mentioned about between Rwanda's, not right now, Rwanda's effect on whatever, or contribution on whatever is happening in Congo right now.
Okay.
Yes.
Very good questions. Gentlemen, you wanted to ask a question, yes? Sir.
Oui, merci, monsieur le procureur. Je m'appelle Barthélemy Sebouyangue, je suis avocat, provenance de la République démocratique du Congo. J'ai deux petites questions. Vous avez évoqué le procès de Kavumu, où moi personnellement j'avais assisté les victimes, j'avais assisté les femmes, j'avais assisté les enfants. Et c'est grâce à l'ONG Trial International qu'on a eu à faire condamner un grand poisson, un grand leader qui était député provincial et qui avait sa milice et qui perpétrait des violations des droits humains dans les villages de Kavumu. Et il y a aussi un procès de Minova. Le procès de Minova.
Minova, je connais
Minova.
Très bien. Right.
Oui, oui, en 2012, où il y a des militaires congolais qui fuyaient la rébellion vers Goma et ils s'étaient réfugiés à Minova. Ils avaient commis des grandes violations des droits humains, mais malheureusement, la justice militaire qu'on avait saisie avait donné son jugement qui n'était pas favorisant par rapport, parce que nous, on avait visé qu'on puisse condamner les leaders, parce qu'il y avait les liens hiérarchiques des commandants, mais à notre grande surprise, lors de prononcer des jugements, on avait condamné des exécutants. Bon, maintenant, ma préoccupation est de savoir, je suis parmi les co-rédacteurs du rapport mapping. Moi, j'avais donné mes observations, j'avais fait des enquêtes et des observations par rapport à ces rapports mapping. Ces rapports mapping, nous avons eu l'honneur de documenter beaucoup de violations, de graves violations des droits humains, mais jusque-là, qui reste lettre morte. Maintenant, nous sommes en train de plaider pour la création d'un tribunal pénal international pour la RDC, parce que vous êtes sans ignorer qu'il y a beaucoup de crimes, de graves violations des droits humains, et qui étaient commises, beaucoup de massacres de Kassika, Makobola, il y a des fosses communes qui ont été bien identifiées, bien certifiées, mais nous sommes en train de croire, moi comme avocat, je suis en train de croire d'une complicité de la communauté internationale, parce que On a beaucoup saisi, on a saisi plusieurs fois, on a été invité partout pour plaider cette cause, mais jusqu'à présent, il y a toujours lettre morte. Selon vous, monsieur le procureur, quel est votre regard critique? Est-ce qu'on peut parler du génocide en RDC par rapport, parce que notre pays est victime de la guerre depuis 29 ans aujourd'hui, depuis 1996 jusqu'à aujourd'hui, et aucune enquête indépendante, aucune volonté manifeste de la communauté internationale et aucune proposition. Nous avons beaucoup proposé avec les très distingués prix Nobel de la paix, le docteur Mukwege. Nous avons été invités dans beaucoup de colloques internationaux pour plaider ces cas, afin qu'on puisse créer le tribunal pénal international. Selon vous, monsieur le procureur, est-ce que, vu les exactions graves des droits de l'homme qui ont été commises en RDC il y a 29 ans, est-ce qu'il fallait-il parler du génocide? Si oui, où en sommes-vous par rapport à votre expertise? Ça, c'est la première question. Deuxième question, est-ce que vous êtes d'accord qu'il faut créer un tribunal pénal international pour la RDC pour poursuivre, pour traquer les grands criminels qui ont commandité, qui ont commandé, je peux dire comme ça, et des graves violations des droits de l'homme? Merci.
Okay. Well, three.
Sorry.
You want some more? Okay.
Sorry.
We can do. It'll be a
please
long
be
speech
brief.
then.
Can you
One
be brief?
more there from the
Very,
woman.
very brief.
Très bref.
You one more?
One more I will take. I'll try to
choose-
consolidate my answers.
Can you choose one?
Yeah, the woman here on in the third row on the right.
Thank you so much, Your Excellency. My name is Sarah Taboswa Chemonges from Uganda. I want to also thank you for your personal initiatives, even as you've worked through this whole international crime scene, that you've taken intentional personal initiatives to help out. The question is simple. In Africa, we are known to be very religious. Most of our countries, many people are very religious. We quite treat religion passionately. I would like you to just speak about the place of religion as a driving factor in trying to speak into the aftermath of some of these crimes and probably lessening the reoccurrence or even the interventions. Because, for example, like in the case of Kenyatta and Ruto, I mean, Ruto is known, His Excellency President Ruto is known to be very religious in Kenya. But, I mean, how does religion shape really the reoccurrence or even the, mitigating some of these crimes in the settings, and how can we use it? Then during the course of this seminar, we've been talking about the place of traditional leaders and how, they play a very key role in some regions. For example, we had a case of Ghana and how the chiefs are quite, instrumental in restoration of justice. So I just wanted you to speak about that. You've given the example of course, the Rwanda example of how the community efforts was able to, yes. How can we use really the community leaders going forward, because we've seen that many people don't even comply with the ICC or appreciate the ICC place because of the double standards on African countries. Thank you very much.
Well, some very difficult questions. I guess I started at a quarter of, so I may take 10 minutes on these questions. But let me, the first question in French dealt with Sudan, which I presume was referring to, sometimes one calls areas of Africa Sudan that aren't national Sudan, but national Sudan has had horrific conflict and genocidal violence, particularly in Darfur against African people by often Arab perpetrators. Though, and as the ICC has not been successful in bringing any of the senior people to trial other than the one Janjaweed leader who surrendered. Now we have a horrendous conflict that followed a hopeful period of transition when we hoped that we would have a transition and there were good people that were trying to achieve justice, including many women in Sudan. Of course, The military then took over, and then that military split, and we've had now a civil war for 2 years that's occasioned some of the worst brutality ever. In Sudan, we are often confronted with the peace versus justice issue. Right now, the RSF, responsible, there are certainly elements of the RSF responsible for horrible killings of civilians, including 460 people in the hospital in El Fasher last month, is saying they want a ceasefire, but they want a ceasefire under circumstances that would essentially repartition Sudan, and Darfur and Kordofan essentially would become RSF country, run by people that have evidenced a very strong animus against African groups of various ethnicities in that area. So I'm one who thinks that justice needs to be done there. There needs to be a peace process and agreements. It really needs to begin with truth, a process that's developed locally to tell the truth about what happened, and then some kind of justice program. When the ICC originally got involved in Sudan, a group of African experts suggested that there be a mixed court established, local courts with some international assistance. And I remember meeting with then ex-President Mbeki of South Africa about that. And the government of Bashir gave some lip service to it, but there was no support. I mean, I think that would be the best solution. But it would be a difficult situation given the security. And the world has failed in Sudan, and I just hope that we can get peace and that we can help achieve some justice for these survivors and stop these crimes. But it's a situation in which all our efforts have really been for naught so far. On the question of in trials, do we allow guilty pleas? There were guilty pleas at the tribunal here in the ICTR by 3 or 4 individuals who did agree to assist in prosecution and did receive, to some extent, shorter sentences. They didn't assist very much in the prosecutions, and those were not necessarily strong cases, but there was some consideration of shortening their sentence for telling the truth. And I, as a prosecutor, I like guilty pleas. Rather than spending 3 years trying to prove somebody did one thing on one day, I'd rather have them stand up and tell me everything they did and admit it and have that out publicly than go through that whole process and have them continue to deny. So I think there are advantages to it, and particularly if they will then testify in other trials. Our biggest failure here, and it was before I arrived, and I'm not sure I could have done anything about it, was the Kambanda case. Kambanda was prime minister of the interim government. He was kind of a Johnny-come-lately to the genocide. When Bagosora sent an armored personnel carrier for him on the 3rd day of the genocide, he said, "Whatever you do, don't kill my family." And he says, "Oh, we're not going to kill your family. We're going to make you prime minister." He was in the extremist part of the opposition, so he was okay for Bagosora. And he did give inciting speeches around the country. He may have saved a few people. When he was arrested, he agreed to cooperate, and we took him to Dodoma, and he gave 97 hours of confession about what happened in the genocide. And it wasn't completely accurate, but it was very good and would have given us a lot of evidence in trials. At that time, then he went to sentence, and the prosecutor, Canadian judge, said, "Well, he's admitted to responsibility for the genocide. How can you give him less than a life sentence? Maybe if he cooperates later, we'll give him time off." He said, "Give me a 3-year sentence." The judges gave him a life sentence. I think we should have given him a 20 or 30-year sentence, to be frank, and because he then was never a witness. I went to see him twice in Mali, where he was in custody. I got attorneys appointed for him. We tried to bring him back. Frankly, when we could talk to the president about having a hearing, he says, "I'm not sure any of us will shorten his sentence." So he needs to know that. And so he never testified. And so there were some senior people that got off because he wasn't available. So it was, however, the first conviction in the history of the world for genocide by a prime minister. but it was because he pled guilty. So that's one of the, I think one does have to encourage cooperation, and one needs those admissions. And even if one doesn't cooperate, there should be some concession for acceptance of responsibility. Victims may not want that, to be frank. It's a balancing issue. We had the questions from our Congolese friend, who I salute for representing the victims in Kavumu, the case of the child rapes. Also talks about Minova, which is a trial that I attended, and saw one of the survivors testify, and I saw one of the perpetrators testify. And I know the presiding military judge, who's very, I mean, not every judge is good. He's not an international kind of judge, but he was basing it on the evidence. What happened in Minovu was, this was the first time the M23 took over Goma, and there was withdrawal of, when I say withdrawal, I mean wholesale retreat by Congolese military down the lake, and they came to the town of Minova and committed these horrible crimes. But they did it as retreating cowardly soldiers, etc. And it was hard to hold their commanders responsible. On the other hand, they had commanders that had gone off and retreated and taken their money and left, I mean, you know, et cetera, that were guilty of other things. But they weren't in control of the force at that time. So the judges went on the basis of what they could prove. They had one case of child rape where there were several witnesses, and they convicted that guy, and they convicted somebody else who didn't have a thumb, I think, maybe, because they remembered he was the guy without the thumb. And that was proof. The other people, they convicted them of pillage and things like that because of the proof. And cases are never better than the evidence. Even though you know in your heart of hearts there were all sorts of things that probably you couldn't convict for, but proof, you know, the French system is conviction intime, an intimate conviction. In an English system, it's a common law system, it's beyond a reasonable doubt, and that means a lot of evidence, and that means that the guilty will sometimes go free. The broader issue is what about the injustice of the Congo, and particularly the mapping report, which was a report done by the High Commissioner for Human Rights, my friend Navi Pillay, who'd been a judge here in the Akesu case and then presided in my media case and went on to be an ICC judge and then High Commissioner for Human Rights in Geneva. When she got into office in 2008, she commissioned a report that there wasn't a complete investigation, but it was a mapping of all of the major places in which crimes had occurred in Congo, in Zaire, Congo, Democratic Republic of Congo, RDC, during the two Congo wars. And all of these crimes happened before the ICC came along. ICC only comes in 2002, and it can't go back. You know, it can only go forward. The ICC has done cases in Congo, generally ones out of the northeast, out of Benin, and what I want to say, it'll come to me in a moment, but not even the Kivus has it prosecuted cases, to be frank. And so we haven't had any justice for that period at all. And the president of DRC went to the UN and called for a special tribunal or an international criminal tribunal for Congo. The government did not press very hard for it, and the international community did not embrace it. During my tenure as ambassador, I went to the RDC 15 times, Kanswa, and I became the advocate of the chambre mixte, the idea of mixed courts with international and national judges that be constituted in the Congo that could try the cases of the mapping period. I had, in all of my meetings, I had support, but from the Speaker of Parliament to the President of the Senate to the President of the Republic to the Justice Minister, everybody was for it. Never happened. because obviously there were people in power that were going to be affected by it, who were involved in the war. And there was obviously concern about Rwanda. Yeah. And Rwanda did not want to see this happen. As a matter of fact, when the mapping report came out, and it stated that what had occurred was a genocide, the Rwandan government announced that it would withdraw its peacekeeping forces from Sudan. And if you know the Rwandan peacekeeping forces, they are tough guys and women, and they're very effective. They've been very effective recently in Mozambique, as a matter of fact. They are very much prized to have Rwandans in UN peacekeeping missions to protect people. But Kagame was saying, if you come after us in the Congo, they're out of Sudan. And so the report was watered down as a result. And the same sort of international pressures continue. I dealt recently with the Justice Minister Wagner, the woman who's foreign minister. She's foreign minister now of Congo. And she, will you support a mixed court? Can we get something going? But then speaking to one of her key aides, he said, well, you can talk about it, but the international community will not support it. It's just not going to happen. So you can talk about it, we can talk about it, but it won't happen, et cetera. And so it was very, very discouraging speech, but the justice is still there. Now, there is this Lumbala case on trial in Paris, if you followed it. Lumbala is at the very tail end of the mapping period. He's in the Bemba group. He's not associated with Rwanda. He's on trial now in Paris, where he lives. And so that is one. So you will have potentially these cases in third countries when perpetrators turn up in those countries and when the evidence can be presented against them. And many times the people involved in these crimes gained a lot of money, control minerals, put their money in other countries, travel. So there is some possibilities of justice out there. But at the international level or at the Congolese level, I think it's unlikely. The last question was about religious leaders and traditional leaders. And fortunately, with the exception of the crimes of, say, Boko Haram in Nigeria, the conflicts in Africa have not been fought. There hasn't been a religious aspect to them. There have not been those kinds of crimes, though obviously we have the crimes in, I should say, of course, in Mali, we've had the takeover by the Ansar Dine and crimes in Timbuktu, et cetera, by jihadists, I suppose. So sometimes you see religion figuring, but not as much as it has in Europe or the Middle East. As the general rule, religious leaders, I mean, when it comes to prevention and we're dealing with the situation, from a diplomatic solution, one always turns to the religious leaders and asks them to meet with the combatants, bring groups together, and try to establish peace. If you've seen the film, the documentary, Pray the Devil Back to Hell, I don't know if you've seen this film, it's about religious women, not leaders, but women, lay women, who were active in Liberia, in ending the war in Liberia in 2002, 2003. And Lema Bowie won the Nobel Peace Prize, or shared in the Nobel Peace Prize for her role in that effort. The movie expresses the women through the churches of Liberia, which has, of course, Muslims, but is more Christian. They pulled leaders into the churches, including Charles Taylor, and said, we must have peace. And they encouraged the peace process that led to the Accra Accords that ended the conflict and that sent Taylor into exile, and that led to a transitional government and then eventually an election in November of 2005 where Ellen Johnson Sirleaf was elected. So it was, it wasn't the Sunday sermon people that put it together, but it was very much a religious effort for peace on women's part. Now, it of course runs a little, the whole peace process sometimes runs up against justice. And in Liberia, the peace agreement ended up with all of the groups signing, Taylor agreeing to go, and then many of the women, if you've seen the movie, say, well, none of the people that were involved in the war should be in any political office thereafter. And everyone that's advising the women says, well, that makes no sense, then they're never going to sign the deal. And so they signed the deal, and so you had obviously people that were involved as warlords who then became leaders in the parliament, et cetera, and had the ability to protect themselves. And so in Liberia, even though you had perhaps 200,000 dead, and the worst examples of the sexual slavery and forced marriage and everything else, you've not had justice at the national level. The only case that we've had internationally was Charles Taylor in Sierra Leone court, but that was not for what he did in Liberia, that's for what he did in Sierra Leone. And then we've had some international cases with various warlords held responsible in courts in America and in Europe. But, and I was in Liberia earlier this year, met with President, the new president, and who set up a War Crimes and Economic Crimes Commission to establish a court. But I'm not, if they do it, it'll need a lot of international assistance. I'm not sure the international assistance is coming, and I think the chance that we will see justice for the crimes in Liberia is very small because of the nature of the peace process. But I mean, for a long time it was Prince Johnson, who became a senior senator, who was one of Taylor's lieutenants, who became head of a violent group, was famous for killing President Doe and chewing off his ear and everything. And he always opposed court. He's since passed away. There's some hope that it will have justice now, but it's a long shot. But as I say, that's when you have those sorts of processes, sometimes you don't end up with justice. That's the decision. And traditional leaders can perform, I think, very important role in trying cases of injustice and deciding whose land that belongs to, in returning property, sometimes in penalizing people. They're not good with sexual violence crimes. Those are very disturbing in the community, and there's been really no examples of traditional leaders being able to try those cases. So, but to the extent that one can, and certainly when I was in Sierra Leone on my missions, I would always go first to the paramount chief and pay respects and talk about the community, et cetera. I mean, it really is fundamental to these communities to have those traditional leaders. But during the conflict, they're often sometimes the first people to be killed, and so their influence is limited sometimes after the conflict. But it's a positive way to go, and given what I've told you about international justice, I will take progress on any front that I can, to achieve justice for the survivors of these crimes. I think, she's been holding her hand a long time. I guess we'll take the two questions, you and the ambassador.
Thank you very much.
Yeah.
May I request those who are asking questions to be very brief?
Okay.
Because
and then you can request the speaker be even briefer, right?
yeah. We'll talk about the speaker later. So can we give the floor to her?
I will be very brief.
This one?
Uh-huh. Yes.
From your international crime that you have shared with us this morning, I just want you to assess what is currently going on in my country, Nigeria. How will you describe what is placement? Does it qualify as general? My question is coming from the fact that there's been accusation of complicity from the Nigerian government, and in one of my research, I had actually called for international inquiry, so we know exactly what the position is. So, as a prosecutor, I think it would be very insightful if you can assess the situation or tell us what your assessment is of what is currently going on.
Okay. Okay, Nigeria question. Yes, Ambassador?
Thank you. Ambassador Rapp, Excellency, Thank you very much for your presentation. It really added to my understanding of what happened in those areas that you mentioned. Yeah. Back on ICC, do you think it's fair to say ICC's influence and power is failing, given the challenges that it is facing? Lack of universal membership, universal acceptance, issues related to state cooperation, accusations of biasness. I'm afraid that we are going back to ad hoc tribunals, special courts, like you mentioned, the one in ECOWAS region. Yeah, it's kind of a hard truth, but I think this is the case, and I'm really disappointed because, well, I took part in the preparatory process from New York to Rome, 1998, where we really celebrated to have ICC statute, knowing that we are going to have really world court that is going to deal with impunity. Thank you.
Yeah, the last question. Back there? Oh, over here, yes, right.
Bonjour. Je me présente, je suis Khadija Traoré. Je suis juge grade exceptionnel à la Cour constitutionnelle du Mali. Mais avant, moi, j'étais avocat, plus de 30 ans de bar, et j'étais même inscrit à la CPI. J'ai donc eu à être conseiller de permanence, parce que le Mali, quand même, est victime de terrorisme depuis des années. Et je tiens à éclaircir un point de fait par rapport à la Cour pénale internationale. C'est vrai qu'aujourd'hui, notre pays ne fait plus partie de la Cour pénale internationale, mais la Cour pénale internationale, il faut faire partie de la Cour pénale internationale. Et il faut que l'État donne son accord pour la poursuite. Donc, moi, je n'ai jamais été d'accord pour le fait qu'on dise qu'on juge les plus faibles et les plus forts, ainsi de suite. Parce qu'il faut l'accord du pays pour juger. Et par rapport à toutes ces atrocités ici qui sont en train de se passer à travers le monde, moi je pense qu'il est temps, à notre niveau, au niveau de l'Afrique, de se donner la main pour créer quand même des structures en charge par rapport à toutes ces atrocités, à tout ce qui se passe dans notre continent. Et déjà au niveau de nos législations, on doit prendre en charge certains crimes. On doit prévenir. La guerre aussi, ça ne se prévient pas non seulement au niveau des armes, mais au niveau du droit. Il faut prévenir, il faut avoir des mesures législatives pour le viol, pour les homicides, pour les violences sexuelles. Nous, déjà, à notre niveau, on a pu, compte tenu du fait qu'on est confronté au terrorisme, on a pris des dispositions déjà dans notre procédure par rapport à tous ces crimes-là qui vont se créer. Donc, il est temps que l'Afrique aussi se donne la peine de prendre en main son destin pour prendre en charge toutes ces atrocités qui sont en train de se passer à travers le monde. Je vous remercie. Comme je ne suis plus avocate, je suis juge constitutionnel, j'ai la réserve. Je m'en tiens à ça. Merci.
Okay. Well, very good. I guess that's the end of it, and I think the last two questions relate together. Obviously, the ICC, as I've explaining, has an impossible task to perform, given and to have the impact that we would like it to have. I'm from the United States, so what right do I have even to speak to the question? My country hasn't adopted the Rome Statute. I wish it would. And subject itself to the court, though we are subject to the court if we commit crimes in Afghanistan or places like that. But it's still important to have broader membership. I do think you need an international court of last resort, but it should only do a few cases and the whole emphasis should frankly be, as we discussed, at the national or regional level. That would be the much better approach. The political will, however, is generally lacking at that level unless you've had a transition in the country and a great desire by the new leaders to try the old leaders, et cetera. And so, and usually, as I noted earlier, the Malabo Protocol that does have the broad jurisdiction, not just of the war crimes, but also of transnational drugs and terrorism and things like that, only one country has signed up. And so my message is, statute may not be perfect, but put it into effect, establish it, et cetera. But that said, it'll still be a matter of having to hire all sorts of investigators and pay them to work here in Arusha or somewhere. So it's much better if you do things in the national system where there are already police and there are already judges and there are already court buildings, et cetera. And that's where I would put the most emphasis for justice. And if that happens, then one doesn't need the ICC. Nigeria was the other question that I had there at the end, and I presume that you're talking about the crimes, just to be clear, because obviously we've had horrendous crimes committed by Boko Haram in the north, taking of thousands of schoolgirls and exactions, and it's generally these Muslim extremists against Muslim communities, et cetera, that have suffered. And the Nigerian system has tried to do justice there. I've been there trying to help work on investigations. Quite often the investigations fail because they don't bring the information in from the war, and they have trials, and sometimes some very big trials, and many people are acquitted. And that shows the system is just, in my view, but that's because the proof isn't adequate. But that's horrendous crimes for which which the north of Nigeria is suffering in particular, in the whole country. That needs to be dealt with, as well, of course, the more controversial questions of whether the government is mistreating the detainees, et cetera, and whether there should be justice on that. And the prosecutors of the ICC have been unwilling to step into the case because Nigeria is so powerful, because they hear we don't have too many cases in Africa, and the idea is let's do this at the national level. So I don't see the ICC getting involved, to be frank. Now I think you may be talking about the crimes that the Trump administration is beginning to talk about Christians, Muslims in the Middle Belt, and the fact that there are areas of the country where Christians are suffering. Is that what you're talking about? Yeah. And I'm a little, I don't sound like much of an ambassador from the United States, but I'm a little afraid of my government rhetorically trying to make that like, South Africans mistreated, white South Africans, et cetera, one of those issues in which they try to demonize African countries, et cetera. So I'm a little sensitive about it. On the other hand, there needs to be justice in those cases. And if I were ambassador, I would be with the survivors of those crimes. I would be with the government. I would be talking about what was happening and the proof that was necessary, and the importance of establishing justice, and involving all communities in a process that would ensure that there weren't crimes committed on a religious basis and that there were perpetrators held to account. I'm not sure we're going to see that, but that's what I think would be the best solution in that situation. Now, we know the politics of the country and what people are likely to become president, et cetera, and we know the divisions that even caused the Civil War, 60 years ago, and some of those divisions still exist today. So people distrust political leaders, but it does involve, friends of Nigeria as a great country, and as an important partner and a leader in Africa, leading the way on these issues. And so I'd certainly be trying to, achieve justice for these victims and stop these crimes. We'll see I mean, if there's anything I can do, I'll get involved for my ex-ambassador role. But that, I think, is that more localized solution would be the better one. It wouldn't hurt if the ICC said it was interested and cared about it and was watching, because I don't think the government would want to get crosswise. But I'd much prefer that in the end that they stay out of it. So anyway, thank you all for your attention today and for all these great questions. Thank you much.
Thank you, Stephen. There is one important thing that I had forgotten to say about him. He is a library of international criminal justice. You have seen it yourself. And you have seen, you have given a holistic approach while also touching the specific areas where these atrocities have been perpetrated. And you have also helped us reflect on the way forward. This library, ladies and gentlemen, is open. That is the good side of him. And it is open 24 hours a day, 7 days a week. And and it's open at any time, I mean. From now that we're going to take our coffee downstairs, you can still approach him with whatever question you have, as many as you may be, he will answer you. Consider that he's still tired because he arrived last night, so he had not had enough time to sleep. And unfortunately, also his luggage was missing. So as you use this library, put in your mind. Yeah. So, ladies and gentlemen, let's give him another round of applause. Thank you. Now we are behind the schedule, but we will try to catch up in the process. And this is time now for tea, coffee break. Let us try to be as fast as possible. You may even think of bringing your coffee here in the room so that we try to save time. Thank you. Thank you.